Hello, Judge. I would like to begin by reading out a statement. This hearing is in the matter CFI 054-2018 before Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Dentons & Co. Lead counsel is Rupert Reed QC. The first defendant is a litigant in person. The second defendant is a litigant in person. The third defendant is represented by Evershed Sutherland International LLP. Lead counsel is Thomas Plowman QC.
Thank you very much. Yes, Mr. Reed.
Well, my lord, I can begin by saying that I'm very pleased to say that the claimant has compromised its claims as against the third defendant, that's to say, Prime. I believe a consent order, a draft consent order has been circulated, and your lordship has seen it. That was only finalised.
I saw it in the last quarter of an hour or so, yes.
I saw it about quarter of an hour before that. So we haven't had a lot of time to absorb it, but it's that there is the order. We would seek the court's making of that order. There is a confidential agreement that is referred to on the face of the order, but that will remain with the party's solicitors. It's not intended that should be filed in court, and it remains confidential.
The only my initial concern is that if the agreement involves the payment of any money, I don't know if it does or not, and I'm not going to ask at the moment, then that might impact upon the amount of any damages against any continuing party.
Well, I have two thoughts on that. Firstly, ordinarily, if we'd proceeded against all three defendants, if they had been found to be jointly and severally liable, and we would have had judgment against all of them, subject obviously to the rule against double recovery. So we would have been prevented from double recovering. So that rule will continue to operate, notwithstanding that we have a compromise as against the third defendant. If there are any continuing concerns about that, then what we could have is a hearing, a separate hearing on damages to deal with the amount, and that could potentially be dealt with at a later date, confidential or in closed court. So there are mechanisms which are available with which we could deal with that.
Yes, thank you. Well, Mr. Plewman, do you want to say anything about the settlement agreement?
No, my lord, just to confirm, that is an agreement entered into by the claimant with a third defendant, and we'd ask your lordship to make such an order, and if your lordship makes such an order, we'd then ask to be excused from the proceedings.
Yes, can you just give me a second while I bring the order up again, just to check there's nothing I need worry about.
As I have it, it is in bundle C 138.
It's got in the bundle already.
The registry were very quick and loaded it up this morning.
C138. Oh. No, I haven't got that on mine. Can you share it? Mine only goes to 137. My bundle C, it hasn't changed. Maybe if I press the word change, it'll.
Or if you refresh it, is your lordship on the live link to case lines?
Well, I'm on the case management system, which I think is the same.
Yes, it should be.
Maybe it will. Whatever, I can bring it up via the email if you just give me a second. Oh no, hang on. Hang on. Yes. Yeah. You're content with that, Mr.
Yes, we're content with that order, and obviously there is a confidential agreement which deals with other matters.
I think I should, although this is not with consent of the first and second defendants, I should ask Mr. MEHTA whether he has any observation at this stage. Mr. MEHTA, can you hear me? Mr. MEHTA? Mr. HITESHKUMAR?
Sorry, Mr. HITESHKUMAR, you're muted. Can you please unmute?
Mr. MEHTA, can you hear me? Mr. HITESHKUMAR, can you hear me? Mohammed, can you find out whether, is it a question of Mr. MEHTA being muted or is it some other problem?
My lord, I will check with Ijaz and I'll get back to you. But he is muted. I can see that he is muted, so I suspect it might have something to do with that.
Lord, while we're waiting, I should perhaps just add that I don't think Mr. Reid intended to suggest anything as to what the contents of the confidential agreement between the parties are. Certainly, your lordship should make no assumptions about that. It is confidential, so I don't intend to address it one way or the other.
Yeah, thank you. I don't think Mr. Reid told me anything about it, and I certainly didn't understand him to tell me anything about it.
Thank you.
I'm sorry to keep you hanging on, Mr. Bowman, but I think it's right that in these circumstances, Mr. MEHTA should at least be made aware of what's happening before you're released.
Yes, certainly.
Sort of staring blankly into space. Would it be sensible to simply adjourn for 10 minutes and see if we can get any proper contact with Mr. MEHTA in the meantime? Everyone happy to do
that? Thank you, Lord. What time does your lordship want to reconvene?
What time is it now? It's
12 minutes past.
I mean, should we just make it 9:30? Would that be the best thing?
Yeah, so that's 12:30 Dubai time.
12:30. Sorry, yes, of course. Should we make it? Mohammed, what we'll do is, if you can carry on trying to establish a proper link with Mr. Mehta, the rest of us will, well, not formally adjourn, but just mute ourselves and turn our cameras off until 12:30 Dubai time. Yes, 12:30 Dubai time. Is that okay?
Okay, my lord.
And once you get
Yes,
Mr.
my lord.
If you get Mr. Mehta working properly, can you keep him there and don't allow any wandering?
Of course, my lord.
Thank you very much. Right, we'll meet again at 12:30.
Okay.
My lord, we have gotten Mr. HITESHKUMAR present. He's currently on screen.
Yes, thank you. Is Mr. HITESHKUMAR, is it? Should I call you HITESHKUMAR or Mr. Mehta?
Anything, I think it's fine, sir.
Which do you prefer?
Mr. Mehta, yeah,
Okay, we'll call you Mr. Mehta.
for you, yeah.
Right, now we'll then resume the hearing. I'm not sure how much you heard at the beginning, Mr. Mehta. Mr. Reed, who appears for the claimant, and Mr. Pluman, who appears for the third defendant, Prime,
Yeah.
have told me that their clients have entered into a settlement agreement between themselves,
Okay.
and the terms of that agreement are confidential, as they're entitled to be. But the consequence is that they are seeking an order that the claim against the third defendant is dismissed, and the freezing order made against the third defendant is discharged, but that none of that affects the existence of the claim against you or the freezing order presently in place against you. Do you understand what I'm saying?
Yeah. Should I say something, sir?
Do you want to make any observations about that?
Yes, sir. I want.
Really, about the question is, on the face of it, they're entitled to dispose of the claim between themselves as they see fit. But it's a matter for you. If you say that shouldn't be the case, then let me know why.
Yes, sir. Sir, actually, the whole case, the issue is that bank paid money to Prime Energy, and actually it need to be, which is almost established that money is lying with them and it need to recover from them only. And there are lots of irregularities in third defendant witness statement, which we already explained. And that's the reason that, without third defendant, running this case will be meaningless. And we have also right to know that what is the settlement between them. And if there any settlement between them, then we should also offer them settlement and give us some reasonable time. So we should also settle with claimant, whatever the claim. And if it will not settle, then we are ready to face the trial in future. And we already submitted application number 16 and 17 also, where there are lots of documents also still missing in the case. And unfortunately, we lost our solicitor and we don't having a defense counsel. So once again, we request court that also give us opportunity to discuss with claimant. And yeah.
Mr. Mehta, if I can stop you for a moment. When we have dealt with the question of the settlement between the claimant and Prime, then there will be questions arising in the context of the claimant's case against you and RENISH,
yeah,
where the points you make may be relevant there. I'm not sure that they affect the question of the settlement between the claimant and Prime. Do you understand what I mean?
Sir, actually, it is very much related with the Prime, because ultimately money is lying with the Prime. And if they settle, then even my resource to recover money through this case will be also over. So that's the issue, and we also having right to understand what are the terms condition, on which terms condition they settle this claim.
They're entitled to settle they're entitled to maintain confidentiality if they choose to do so about the terms of the settlement. All they are seeking is an order from the court dismissing the claim against Prime and discharging the worldwide freezing order against Prime. And there's nothing. I'm only interested at the moment in excuse me, in the question of whether you can say anything that is relevant to stop them doing that. The question of the claimant's case against you will be discussed once we've dealt with this matter.
Yeah, actually, sir, in this case, discharging Prime is most disadvantage for us, because as I explained before, the money is all paid to Prime, not to the RENISH by the bank, and discharging them, the whole case, I don't know how it will run further, because the bank paid money to Prime, not to RENISH actually.
Well, that's a point that can no doubt be made in the case against you when the bank makes its case against you. I think at the moment all I can do is give effect to the settlement agreement and make the order that's sought, and then and that will mean that Mr. Pluman can disappear if he wants to, and then we can consider the position as between you and the bank. Do you understand that?
Sorry.
And then we'll discuss the matters arising between you and the bank, and where we go from here. So, Mr. Pluman and Mr. Reid, I'm prepared to make that consent order, the terms that's been given to me. And in those circumstances, Mr. Pluman, you're free to go if you wish to.
Thank you very much, my lord, and I'm sorry this didn't happen at a time that might have relieved your lordship of at least some of the preparation, but that's in the nature of these things sometimes. But thank you very much.
Thank you very much.
Thank you.
Now, sorry. Mr. Reid, where do we go? Mr. MEHTA is here, as I understand it. Your claim against him continues, but it must be affected to a certain extent by your settlement with Prime.
My lord, it has been affected to a very significant effect, and there are two consequences. First, well, three possibly. Firstly, in terms of the opening, we would like some time to restructure our opening to save the court time, so that we can remove material that only relates to, for example, the restitutionary claims or the conspiracy claims. There's a lot of material that no longer needs to be opened before the court. So with your lordship's indulgence, we would ask for some time to do that. And also we will need obviously to look at the proposed cross-examinations, because currently we were going to be cross-examining Mr. Farhang and Mr. Sadr. They will not be cross-examined. Much of the material on which we would be cross-examining them will now need to be put to Mr. MEHTA. So if we could have some time to do that. As I say, the settlement was being negotiated for much of yesterday and was not finalized until this morning. So we haven't known that it would be finalized, and therefore we've had to maintain our case on the footing that we were proceeding against all three defendants. Now that we know we have the settlement as against Prime, it would certainly help in terms of rearranging our material for opening the case, and also restructuring our cross-examination of Mr. MEHTA. There are consequences.
So can I ask a question which you may say is none of my business? And if you do, so be it. You have a money judgment against Mr. Mehta already for the full amount of your claim. I understand the purpose of continuing against Mr. Mehta. When I say Mr. Mehta, I'm including RENISH as well. But if I just say Mr. Mehta, you'll understand I mean both first and second defendants. I can understand why why you would want to continue the fraud claim against Mr. Mehta when Prime were in the picture because of the conspiracy aspect of the claim. But now that Prime have dropped out, do you get anything from continuing against Mr. Mehta? Again, you don't have to tell me if you don't want to.
Well, I think I can say, and we've discussed this before, my lord, in respect of the during the hearing of the application set aside immediately. But our broad understanding is that in terms of, for example, freezing.
It's an enforcement point, is it?
It may assist in enforcement, and so for that reason we maintain our case in all the banks in court.
Right. So that is the underlying reason for it, in broad terms.
Yes, and your lordship will be aware too. We have a freezing order, so there isn't simply an option of discontinuance in circumstances where there would then be matters to resolve in respect of the freezing order. So
that wouldn't disappear simply if the fraud claim disappeared, because there would be the money judgment.
My lord, yes, but we would need a comprehensive settlement with Mr. Mehta, because we would need to resolve all matters in respect of the freezing order and the discharge of the freezing order.
Mr. Mehta, without, again, sorry, this is addressed to Mr. Reid. Mr. Mehta has suggested that there may be scope for discussion. I don't know whether you want an opportunity of exploring that, as well as an opportunity of reframing some part of your case.
Well, Lord, yes, we would like to explore that, but we are very keen to hold the existing trial fixture.
Yeah.
I would make
it will go short.
Well, my lord, we now have plenty of time, because we don't have to cross-examine. We don't have the cross-examination of Mr. Sada and Mr. Farhang, and we also don't have the cross-examination of Mr. Drew, who was the third defendant's expert accountant. So there should be time in the timetable. Our preference would be to postpone opening, if your lordship were reminded to agree, until Tuesday morning, to give that option.
Is that the 5th?
Sorry,
is that the 5th?
Yeah. That's the Sunday the 3rd.
Yeah.
That would give us the time to restructure our opening and cross-examination. But if there was not there was no constructive engagement by Mr. Mehta, then matters could proceed at full speed on Tuesday morning, Tuesday the 5th of October, and we could proceed with the opening. We would probably want more time in cross-examining Mr. Mehta, so we would probably want at least 2 days with him. So the timetable would then be openings on Tuesday the 5th. There's then Mr. Ravi Gunes, who's the witness for the bank. So Mr. Mehta would be entitled to cross-examine him.
That would be on the 6th, would it?
That would be on the 6th. And then Mr. Mehta would be the 7th, which is the Thursday. And then over onto the following Sunday, which I believe is the 10th.
Yeah.
Then we would finish the factual evidence, and we'd move to the expert evidence, and Mr. Mehta would be entitled to cross-examine Ms. Lavin of Grant Thornton, but that should take that's scheduled for half a day, so that should take no longer than half a day on this Monday, the 11th. And then, if we could at that stage have a day to prepare our closings, and then close on the Wednesday.
What date is that? 13th. So, and then Mr. Mehta closing on the 14th. Is that
Yes. Yes.
Could I say something?
Yes, just a moment, Mr. Mehta. I'm just making a note of this, then we'll have to consider, obviously. So, sorry, the 12th would be preparation for closing. Yeah.
Well, yes.
There's a question of what to do about, which I can ask Mr. Mehta about, but about the witness statements presently submitted on behalf of Prime, which I think Mr. Mehta would be entitled to rely upon as hearsay evidence.
Yes.
Is that your understanding? If he wanted to.
It is, and indeed, you'll have seen that many of the witness statements cross-refer to other witness statements, and therefore, if, for example, Mr. Sada's witness statement were to be expunged from the record, then there would be parts of the evidence of other witnesses that would make little sense because they refer specifically to passages and observations in Mr. Sada's evidence. So, yes, I think all the existing trial bundle would need to remain, and the existing evidence of the third defendant would need to remain on the trial bundle, and in the expectation the parties would refer to it. Clearly, there's an issue about how much force can be, how much weight can be attributed in circumstances where the relevant witness has cross-examined.
And there will be bits of those statements that Mr. Mehta might want to rely upon and bits that he disagrees with, and he can do as he thinks appropriate with those statements. Is that your understanding?
My lord, yes.
The only other thing I was going to ask was there's a certain amount, or quite a considerable amount, in the in Prime skeleton argument, which might be said to assist Mr. Mehta's case as well as Prime's case. Presumably, he can that will remain as a document that he can refer to bits of as he thinks helpful to his case.
Yes, he would need to adopt it by way of submission, wouldn't he?
Well, yes. Not necessarily the whole. It's not necessarily all or nothing.
Yes. No, I mean, I think there is an issue in terms of hearsay notices when a defendant drops out. That you can't specifically cherry pick bits of the evidence on which you seek to rely pursuant to a hearsay notice. But I think in terms of submissions, I don't think the same problem exists. I think therefore that you can adopt specific submissions that have been advanced by a defendant who's no longer party to the action.
Yes. In terms of the hearsay, in terms of the statements, it must be the case, mustn't it, that Mr. Mehta can say, I adopt paragraphs 50 to 70, but not 1 to 40. He doesn't have to. None of it.
No, exactly. He can adopt it, but clearly we are, to the extent there are elements of the same witness statement that he doesn't like, we're entitled to put those to him specifically in cross-examination.
Yeah. Follow.
My lord, if we were to adopt that course, the only remaining matter would be the applications, and in our submission, they should be disposed of now, in order not to pick on Tuesday morning, if that's when we're to start.
Yes. Just before we do that, I'll ask Mr. Mehta. Mr. Mehta, do you have a copy of the proposed trial timetable which the claimant prepared?
Yeah.
And have you been following the suggestion by Mr. Reed for the reordering of that timetable so that what he's suggesting is that we have the rest of today and tomorrow for him to reshape his case so that it focuses on the case against you and allows him to develop cross-examination more focused on you, because he won't have the prime witnesses to cross-examine. And what he's suggesting is then, after a bit of reordering of his case, that on the 5th of October, he then opens his case and you have an opportunity of saying what you want to do at the beginning. And then on the 6th of October, it would be Mr. Gunes who would be called, and you could cross-examine him on his statement. On the 7th of October, it would be you being cross-examined on your witness statement. And the same also for the 10th of October, you being cross-examined by Mr. Reed on your witness statement. So that's 2 days worth of cross-examination. Then on the 11th of October, you deal with the evidence of Claire Lavin, that's the expert for the claimant, and that would only take probably through the morning. And then it's suggested that the 12th of October be a day for preparing closing submissions. 13th of October would be the bank's closing submissions, and the 14th of October would be your closing submissions. Now, leave aside the applications that are being made. We'll deal with those in due course. Are you content with that as a timetable for proceeding with the case? I should have said that Mr. Reed, I think is, at least in principle, open to the idea of you and his solicitors discussing matters if there's a possibility of settling the case, but this timetable is proposed on the basis that no settlement is reached. Do you understand me?
Yes, sir.
And are you content with that timetable, or is there anything you think ought to be in it or ought not to be in it?
Sir, I want to say something.
Yes, sir.
That removing prime and from this case will be have serious implication on this case. And this surprisingly happened just today morning, and there is no prior information was provided for this. Secondly, sir, although Denton and claimant remove them from this, but this case is very much related to prime. So whether they want to continue with them or not, that is different thing. But we would like to cross-examine Mr. Sadar and Mr. Farhang in this case. And our main concern is, sir, that I don't having any defense counsel or solicitor at the moment. So whatever their new filing, really it's very difficult for me to rejoin the case within such a short period and give my explanation and all this. So my request is that please give us some reasonable, vacate current trial and give any other date, a reasonable time. So by the time we should able to find our defense lawyer, we should take legal advice on their submission, and then the fair trial will go on. So that is our request, that it should be somewhere in beginning of next year. So once they will make all the fresh submissions, so it will be good for us.
Well, the difficulty is, Mr. Mehta, that what the removal of prime from the case narrows, removes some of the issues and narrows other issues. But the case against you, I'm going to call it a case in fraud. You understand the case I mean. That seems to me, it remains the same case, effectively, as has been made before the removal of prime. And I don't see that the removal of prime requires me to give further time for you to defend the case. It seems to me that you will have time to consider the revised way in which the case is put against you, in light with the timetable that's been suggested. As to you wanting to cross-examine Mr. Sada and Mr. Farhang, and there are parts of their evidence that you rely upon, presumably.
Yeah.
And parts you disagree with. If that evidence can be placed before the court in written form without cross-examination, Mr. Reid, is there any way in which, procedurally, in which Mr. Mehta can cross-examine, can ask the court to order attendance of those witnesses for cross-examination?
Well, he would need to have served a witness summons, wouldn't he? And I'm unaware of any instance of witness summonses being served out of the DIFC, out of the jurisdiction.
They're out of the jurisdiction, are they?
Well, Mr. Sada, I'm unaware of him being in the DIFC.
What rule is it? What rule of court is it?
I think it's RDC Part 30 in the law.
Part 30.
From memory. Party must obtain permission from the court where he wishes to.
Where are you reading from?
Reading from 30.12.
Yeah.
Party must obtain permission from the court where he wishes to have a summons issued less than 7 days before the. Well out of time.
But I don't think I can use time. I don't think the question of out of time can be used against Mr. Mehta in circumstances where the witnesses were lined up to attend and he's been taken by surprise by a settlement. But I'm looking more at the substance of it rather than timing. Is there anything about service out of the jurisdiction?
Not within Part 30.
Is there any other part that might help on this? It seems to me one way around the matter, Mr. Mehta.
Yeah.
Just explain, Mr. Mehta, the difficulty with cross-examining Mr. Ali Sada and Mr. Farhang is this, that they presently, I think, are both out of the jurisdiction of the Dubai DIFC court. And there doesn't seem to be any way in which a witness summons can be served on them to make them attend. One way around it would be for you to identify in advance those parts of their evidence that you wish to rely upon, because you say it's favourable to you, and at the same time identify those parts which you challenge. And then when you give your evidence, you could explain in your evidence in chief before you're cross-examined why you challenge those parts of their evidence and give your account, and then you can be asked questions about that by Mr. Reid when he cross-examines you. You with me?
So that's why, sir, my suggestion is that still, yeah, exactly. So I'm okay that Honorable Court give us some time so that whatever document removed from the case, and then everything should be rescheduled, and then they submit their fresh allegations. So, and what document we should use, accordingly we should prepare our trial. So give any other trial date by beginning of next year will be great for us, sir.
Mr. Mehta, I don't see any basis at the moment on which to adjourn the trial fixed for now, but I will give you every opportunity to adjust your case to the new circumstances. But the case against you will remain the same. The case against, it may be more limited, but it won't be expanded because the claimant is confined to the case he has put on the pleadings against you, and he's not expanding it at all.
Sir, I don't want to adjourn the case, but I just want time for preparation, because now what material I can use, what I can't, and there are lots of unusual things happen for me. So I just need time to prepare. Said first, I understand what evidence now available for the case, and also we also need some evidence from bank side, for which our application is also pending. Application number 7.
We'll come to that application in a moment.
Yeah.
But
so we simply request that give some reasonable time. So by the time I also anyhow procure my defense lawyer and solicitor, which help me to prepare this case, and also we should prepare reasonably to avoid anything else.
My Lord, we've proposed a timetable that essentially gives Mr. Mehta 2 days to adjust. As your Lordship said, the case against Mr. Mehta and RENISH has always been a case in deceit. The dealings with the bank were those of Mr. Mehta and of RENISH. That case in deceit remains, notwithstanding that the conspiracy claim made against Prime has been compromised, but the case is exactly the same. This trial has been listed for months. A huge amount of work has gone into preparation, and in those circumstances, the suggestion that Mr. Mehta now needs more time, albeit that he appears to have been significantly legally assisted, notwithstanding that he appears in person, that would do great prejudice to my client, to the bank, which wishes now to proceed with trial, subject to a short hiatus to allow recalibration of the case in the light of the compromise against the third defendant, and a hiatus, I should say, too, which would give some opportunity to the bank and the first 2 defendants to engage in some sort of constructive dialogue. But if there is no willingness to engage in that dialogue, and if no progress is made, then we will need to proceed, and we would ask that we proceed on Tuesday.
I think it's right that although Mr. Gunes is down for a whole day of cross-examination, I can't imagine it would take a whole day. There'll be more time built into this timetable to allow Mr. Mehta further opportunity. Mr. Mehta, I think you've had Mr. Sada's evidence in writing already, and you've had an opportunity of seeing that. Is that right?
Sir, I have 2 things that, see, I am not aware about custom and practice of law and all this. So really 2 days for people like me who is really have no knowledge about laws is really impossible, sir.
These witness statements deal with the questions of fact, which you either agree with, disagree with, or say you don't know about. These are matters that you've had, and Mr. Sada's statement has already been with you for some time.
Yeah, one more thing I would like to say, that, sir, releasing third defendant will have serious implication in this case, because the money is lying with the prime energy. So if you discharge them from this case, actually I have no remedies at the moment to recover that money, and even bank will also suffer loss following that. So,
Mr. Mehta, you have no claim against Prime in this action.
actually, it is connected with the prime, and bank paid all the money. The matter of fact is that to the prime.
Yes, but you have no claim to recover money from Prime.
Sir, I already initiating that process.
Yes, but not in this action.
Sorry?
But you have no claim in this action against Prime.
Yeah, because this case is going on, so not, but then I need to file case against Prime to recover my money, and then following that, I will discuss with the bank as well.
Well, I think what we're going to do, unless you have any detailed points to make on the proposed order, what I will do is allow the timetable to be adjusted in the manner set out, and perhaps, Mr. Reid, you could provide a typed version of the revised timetable. It seems to me that that will give you an opportunity, Mr. Mehta, of considering which parts of Mr. Sada's evidence and Mr. Farhang's evidence you want to adopt, which parts you want to challenge, which parts you simply don't mind either way. And that can be done before you give your evidence on 7th of October and the 8th of October. And at the beginning of your evidence, you'll be entitled to point to those parts of Mr. Sada's statement and Mr. Farhang's statements as matters you, as I say, that you adopt or you disagree with, and so that the cross-examination can proceed on that basis, with you having the opportunity to giving your account of the matters that they deal with in their statements. So that's the order I'm going to make. And then on that basis, we need to deal with the applications that have been made. And can I just be clear which applications we're presently needing to deal with? Mr. Reid, can you identify it in the bundle? They're
being referred to as application 16 and 17. They're in the Y bundle, my lord.
Oh yes, there we are. Yeah.
We're trying.
Yes.
Okay.
The first is to vacate the trial.
Okay, so the first is at page 1, which is, yes, further application for deferment and orders in relation to monies in the Dubai, in his Dubai account. So I think there's some suggestion that monies have been frozen in his Dubai bank accounts, and that there's an order that this court can make in respect of those monies, which I believe is an application that's already been before your lordship.
Yes. What do you say about it, Mr. Reid?
Well, we say that this is an application that's already been made. If one turns to bundle C, you'll see your lordship's decision on that at page 125.
Yes. 125, you say?
That's your decision on the deferment application when it was made on the previous occasion. So the suggestion that Mr. Kankani is unable to return to Singapore. We understand that the evidence has been slightly expanded. It's now suggested that the reason that Mr. Kankani is unable to fund Mr. Mehta is not only because he's unable to get to Singapore physically and therefore to release monies held in a Singapore account, but also the pandemic may have affected his receivables. His business in Singapore may have been affected, and therefore his willingness and or ability to fund Mr. Mehta may have been affected by the pandemic. We can look at that in a moment if Your Lordship feels it necessary.
That Mr. Kankan, is that Mr. Kankani's witness statement?
Yes, sorry, I will find that within bundle Y.
It's Y17.
So in paragraph 6 of that witness statement, you see he's adding to the issue, the existing issue on which Your Lordship has already considered, which is his inability to access funds by reason of his inability to enter Singapore. But then 6.2, furthermore, due to my absence, the collection of payments receivables for my business is now delayed, following which I'm unable to mobilize funds from other possible sources as well. So that he's now alleging an additional problem in terms of raising funds. I mean, there is arguably a need to stand back and consider that Your Lordship will remember the application to set aside immediate judgment was some months ago, and the trial has been listed, I believe, even before that. So as of the date of the setting aside of immediate judgment, Mr. MEHTA has known exactly what is required in terms of the trial. Clearly, he's entitled to seek legal representation. He's entitled, if he can pay for it. I mean, our strong impression is that he has some form of legal assistance. When one looks at his skeleton argument, there is clearly some form of legal input into that document, into the presentation of the document, and into the argumentation that's advanced in that document. So we do have a slight concern that what Mr. MEHTA is essentially doing is advancing a case with legal assistance and legal advice, but at the same time claiming the status, if you like, of a litigant in person. The alleged inability to access funds in Singapore is a matter taken to
You faded out then. You said the alleged inability.
The alleged inability to access funds is an issue on which Your Lordship has already given an order. Clearly, this isn't an interim order stands unless the applicant can show that there's been a material change of circumstance. There is, as we see it, no change of circumstance in respect of application 16. We have filed no evidence in seeking to rebut this because there's nothing we can say about the alleged inability to access funds in Singapore. But
you have a complaint, I think, but tell me if I'm wrong, against Mr. MEHTA as well as against Prime, that they have failed to answer orders requiring them to disclose their assets. Is that right? Yes, or is that only Prime?
No, we have, as against Mr. MEHTA and RENISH, we have already sought committal for contempt on the basis of their complete failure to give any asset disclosure, notwithstanding that they have been aware of the order for some time. That application was made, I think, in January by Mr. Wheel. We as yet, there has been no order, but we understand that's just a matter of the court preparing its judgment or considering the application. But there has been an oral application, and
the relevance here is, it seems to me that Mr. MEHTA to plead the inability to get funds, he would have to come out and say what his various assets are and why he can't use them. And if he hasn't yet responded in full or at all to the terms of the disclosure part of the freezing order, then it makes it rather difficult. No, Mr. MEHTA. Sorry. Yes, carry on, Mr.
As Your Lordship notes in the judgment, insofar as there has been no application, for example, for litigation funding. One would expect Mr. to have explained why he has not sought it, or if he has sought it, why he's been unable to obtain any form of litigation funding.
Yes. Oh, Mr. Mehta, you're seeking adjournment, as you said, for into next year sometime, maybe 6-8 months.
Sorry.
You're seeking an adjournment of this case for possibly up to, I think, say 6 or 8 months.
6 months is enough, sir.
6 months. But the problem with that is why you say you haven't got the funding to instruct legal representation, and you refer to Mr. Kankani's difficulties, but you haven't as yet revealed in full what assets you have or don't have in various bank accounts throughout Dubai, India, and so on.
I have that account mentioned also in our application. So if court will order, so we should have access of that fund, and then we should appoint defense counsel as soon as possible. So in that case, even 3 to 4 months will be also fine for us.
But why haven't you been able to use, I mean, you and or RENISH will have bank accounts in different places before the business collapsed.
So my all account is mainly in UAE only, and money is there only. So that's the problem. And
you say
is the account.
You say mainly in the UAE. Are there no bank accounts anywhere else?
Sorry, no, means there is no money anywhere else. In suppose Mauritius bank I have account or anywhere, and all account are freeze due to all these issues. So only which account I suggested, the money is there.
But there's nothing from the bank telling me that if I write a letter to in a certain way or make an order in a certain way, they will reveal the money, that they will release the money to you.
This is money due to this WWFO. So just court advise them that for legal expense they allow me, and also just instruct them that they will directly transfer that money to my lawyer account. So then I will appoint lawyer and get it there.
But how can I just issue an order against the banks without knowing their reasons for not releasing money to you?
You can say that two banks don't having any dues with me, so that money is clear. That is, I'm very much sure.
Well, but this court can't make an order that the banks release money to you without having some proper information from the banks as to what the problem is, why they are not releasing the money at the moment.
Right now, due to WWFO, they completely seized my account. So if my lord give relaxation in WWFO and give instruction to the bank that they can allow to Mr. Mehta request to make payment to the lawyer as per the invoice issued by the lawyer, then I think that will be good enough for us.
My lord, I hesitate to interrupt, but at page C5, we have the relevant provision within the worldwide freezing order.
C5.
And your lordship will see exceptions to the order, paragraph 14.
Wait a sec. Yeah. Yes.
This is the legal expenses exception. So on the face of the order, it's entirely clear that he's entitled to use monies for his legal defense.
Yeah. But last time I understood the problem to be a different one, I thought the problem was that although you had this exception to the order allowing the banks to advance money for your ordinary reasonable legal representation, the problem was that the banks were saying that they had not you had not used the accounts for 2 years, and there was a problem that you hadn't fulfilled, you hadn't gone through the know your client processes. And that's nothing to do with the freezing order.
Actually, I can explain this issue little bit in detail. That due to money freeze, I can't able to renew my trade license, and that's the reason that banks are not allow me to operate other than WWFO. So there are two reasons. So if even I can utilize that money to renew my license, then bank and another instruction from the court that also allow specifically that or allow them to make payment to the lawyer, then I think the problem will be sorted out.
Yes, but the difficulty is that I have that is you telling me now what the bank's reasoning is, but I have no evidence of that beforehand, and nothing from the banks to confirm that position.
So if I just allow to renew my trade license and allow to pay to my lawyer, that should be enough for me at the moment in WWFO.
Mr. Reid, do you want to add anything?
No, my lord. I mean, we do need to know the position now. I would be very concerned about a process that involves us spending the next 2 days liaising with banks, if that's yes. What's proposed.
Well, I don't think I at the moment have nothing from the banks saying that is the problem, nor do I have any basis for making an order to ask the banks to release the money. So I'm not prepared to make an order in those terms, Mr. Mehta. So that application is refused.
Should I say only one sentence on this?
Yes, by all means.
Yeah, for this application number 16.
Yeah.
So actually, I just want to exercise my legal right, and I need little support from the court side. So in WWFO, if the allowance terms is also to the amount I can pay for renew my trade license, so then this problem will be resolved. Then I don't need anything else from the court side. So just in WWFO, court will allow me to pay my fees for the trade license. So I think this problem will be resolved.
But Mr. Mehta, that is different from what you've told the court before, which is that the banks were not allowing you to access the accounts because of the KYC requirements.
Yes, so KYC is only trade license, sir. So trade license once renew, so it will be done.
Well, we have no idea what the timings of this would be.
Yeah, no, I understand that. You have lawyers who have been acting for you for considerable time until recently. Would they be available if money was made available? I'm not going to delay these proceedings,
yeah.
But if money was made available, could they then come in and help you?
Yeah, I think I'm able to conclude all this thing in 1 month.
I'm not talking about 1 month. I'm talking about the trial timetable that's already been laid down.
Yeah.
Tomorrow, in other words, starting with the opening on the 5th of October, as Tuesday.
So within this short period, really, it is not possible. So give us some reasonable time, sir.
Well, I'm afraid that since this trial has been fixed for a considerable period, and nothing in today's proceedings so far have made any fundamental alteration in the burden one.
Surprise is coming on one time. That's the only reason, sir.
Yeah, but I'm not prepared to make to grant the order for those reasons. Now, the next application is? So I'll refuse application number 16.
Number
What's that? 17 is
33, my lord.
yes.
There are 4 heads of interim relief that are sought. The first is the 2018-2019 accounts of Prime, which were in fact provided by Prime and now appear in the trial bundle.
Hang on a second. So where is the list of documents? Those documents requested. That's the financial statement, balance sheet, and so on. They've been provided, have they?
They have been provided. And 2018-2019, 2020 have not yet been produced, and therefore they have not been provided. But we've had that explanation that they don't yet exist.
Yeah.
And they are in the back end of this bundle, so we can and will look at them in due course. And then the second head, Little Roman 2, is.
Am I looking at something different from you? I was looking at where's Little Roman 2?
I'm looking at the application notice at Y33.
Oh, sorry, I was looking at the application, the document after that. Yes, an order to the Central Bank of UAE and so on.
The FSA, which is the financial regulator, and the Federal Tax Authority, ordered to give their opinion subject related and legal financing. So, my lord, this court has no jurisdiction to be making any orders at the Central Bank of the UAE, the DFSA, to render opinions. Clearly, the DFSA has regulatory jurisdiction and is subject to the control of the GFC courts. But it would be extraordinary for this court to give that direction or order that they give it.
And then 3.
To issue order to SBM to identify person who signed the personal guarantee. This appears to be a collateral attack on the contractual judgment, the immediate judgment, which has already been given. This is particularly extraordinary.
Is this raising an issue as to whether Mr. MEHTA signed the guarantee?
Well, I think he's questioning whether he signed it and whether the relevant bank employee in fact signed it.
Yes.
We should, point out that not only is that inconsistent with the contractual judgment that's already been given, but in fact, in terms of the pleaded case of the first and second defendant, if your lordship has bundle B, which is the pleadings bundle.
Yes, I have it. Yeah, tab what?
It's I don't have tabs, unfortunately. I have pages, and it's page 194.
19.
Tab 23, I'm told.
Yeah. Yes.
If you look at
You're cutting out, Mr. Reed. If I look at what?
If you look at paragraph 5 in that defence,
yeah,
you'll see it reads, save that SBM conduct its own due diligence on relation to Mr. MEHTA, it was in no way induced by them to enter the facility agreement. Paragraphs 7 to 11 are admitted.
Yeah,
and then if we go to the particulars of claim 4.
Yeah, I have it. Yeah.
You see there 7 is facility agreement, 8 is facility agreement, and then is the personal guarantee.
What paragraph's the guarantee? Oh yes, I see. Yeah, 10.
So all of that pleading in respect of the personal guarantee is admitted paragraph 5 of the defence of the first and second defendants. And then your lordship has obviously given judgment.
Yeah, that I understand. Okay, what about for the deferring the trial?
Well, deferring the trial is just essentially the same application, but based by reference to these different circumstances. So the initial application scheme was the funding, alleged funding. Application 17, the deferment, is by reference to the need for this opinion, the need for the accounts, and the need for the possible relevant lawyers who were there, witnessed the signing of the personal guarantee. So we say if there's no order made under 1 to 3, and there is no reason to make any order on 1 to 3, then the deferment by those heads should also be refused.
And
insofar as there's been any success in terms of procuring from Prime 2 sets of accounts, that application could have been made far earlier, and they're relatively limited documents, which your lordship will see are now within this bundle. So
where are those documents?
they are in this bundle. Page Y207 is the first page of the 2018 Prime accounts.
I see. I've got them. Yeah. Okay.
And then if you scroll down, there's a different auditor in 2019. That's page Y219. The auditor being the you have the set of accounts.
Yeah. And where is the statement saying there's nothing? The 2020 accounts haven't been produced yet.
That I believe is in correspondence.
Right.
With us.
What?
206. So paragraph 16, bottom of Y206.
Oh, Y. Sorry. Who said I? Yes, I see. Yes, I see. Thank you very much. Mr. Mehta.
Yes, sir.
Looking at your application, which is at Y34.
Yeah.
You're asking for 3 things. One is you want the balance sheets for Prime for 2018, 2019, 2020. Yeah. I think I've been shown the balance sheets, the audited accounts for 2018 and 19.
Yeah.
And they've been given to you, is that right?
Yeah, that's correct. And
2020 hasn't been done yet.
yeah.
So there's no outstanding issue on your first?
So still there is one outstanding issue.
What's that?
The balance sheet we just received 3 days ago. Okay, just in first examination, people like us who don't having a great accounting knowledge, there are lots of controversy coming out, like what Mr. Sadar claimed that he is owing, he having a pen due with RENISH for 52 million. His total outstanding is 18 million. And actually it need to be scrutinized more with the account expert, because this just we received and lots of new thing will be coming out which will help in this case. So that is one.
These are matters you can take up with either in your evidence or with the witnesses.
So actually one account forensic account people should appoint by us, and he will actually identify lots of irregularities. We hope we identify a little bit, but it's just a top of the mountain. There are lots of which will affect to this case.
I think you've been given what you've been asking for in that respect, and if there are any points that arise on that, they can be raised with witnesses. Insofar as relevant, they can be raised with witnesses at the trial. So, what about the second point? I have no power to order various bodies within the UAE to give their opinion on these sort of matters. There's simply no basis upon which the court can make an order of that sort.
Actually, the thing is that finance is a very critical sector, and all the bank right now working, even foreign bank working in UAE, they are also registered with DIFC, and through that regulation only they are working. And this Mauritius launched their product directly in UAE market, and really if regulator opinion will be avoided, the issue is that in future some pharma company register in abroad start selling their drug, or lots of other thing will happen. So in this type of critical issue, because it's a very critical sector which affect economy of UAE, so at least if they didn't do any wrong, we don't having a issue, but the regulator opinion is very much important in this case.
But there is no issue raised in the case about
actually we had submitted Uganda High Court judgment in this regard, that Uganda High Court given judgment in this regard that if any bank not registered in the country, so all that facility considered as null and void. And
there is, Mr. MEHTA, there is nothing in the pleadings in this case about illegal financing.
No, it is mentioned, sir. In November plea also we had mentioned this, and later on also.
Mr. Reid, is there anything in the pleadings that I've missed that deals with illegal financing?
No, my lord, it's not raised directly in the pleadings. It is relevant to the facts, but the relevant legal framework in terms of sanctions, it's dealt with certainly by Mr. Sadar in his witness statement. It's dealt with by Mr. Drew in his witness statement. I don't think any party is disputing that one of the reasons for the arrangements as alleged between Prime and RENISH was to have access to finance in circumstances where Prime may struggle to pass the KYC and anti-money laundering requirements of certain banks. But that much seems to me to be...
No, sir, our question is related to SBM, that SBM is not registered with any of UAE regulator. So that is our question, and that's why we need opinion from the regulator that any bank should operate in UAE, make funding, take deposit from UAE without regulator registration. That is the question, because Mauritius is also in grey list country of FATF. So regulator opinion is very much important. And there is also violation of VAT also in this case. So that's why we also ask Federal Tax Authority opinion.
But I can't. There's no power for this court to order these bodies to give their opinions. But the third matter is about the identity of the person signing the guarantee. But you've never disputed that you signed the guarantee, or that the
we had disputed, sir, in our plea. We had already asking this in November, but so far Denton never clarify. Even after filing this appeal, they simply reply us that means denying to give any more detail. And this was also submitted our plea in our November also.
Well, sorry, what was submitted in November?
That we need to identify these people passport copy.
What I don't understand why, because you admit in your pleadings that you signed the guarantee.
Actually, the problem is not that the signing or not signing. The problem is that the submitted balance sheet, this personal guarantee by the bank, that is also because I signed numbers of pages, numbers of documents. So the question is that is it a same paper what signed by me over there or no? Because the acknowledge there is no witness statement witness sign on this. Although Miss Lobo said that 3 people from bank was available in room, but there is no one witnessing or no one signed this. This personal guarantee submitted by bank, not notarized by any notary. And again, the acknowledgement is signed by 2 people. And as per my best knowledge, the 3 people available in room, as per Miss Lobo, none of having this designation. So that's why we asking these details in our November plea as well. But Denton is avoiding that.
Well, I'm not persuaded that there is any live issue in the case about the signature on the guarantee. So I'm going to refuse to make the orders sought in application number 17.
One more thing, sir. In personal guarantee, the jurisdiction is Dubai court, not DIFC court.
Have you taken the jurisdiction point in the pleadings?
In our skeleton argument, it is mentioned because we just joined this case a week ago. So we are trying to check all the documents one by one, because I am connecting with this case since last 1 week myself. So that's the issue relating to this case.
My lord, that point was raised, well, specifically in the particular claim. It was made clear that the courts of Dubai, the DIFC courts are courts of Dubai, and therefore there is jurisdiction. As I say, that was paragraph 11. Your lordship will recall that paragraph 11 was specifically admitted.
Yes.
And there's a significant body of DIFC case law, my lord, precisely on this point as to whether the DIFC courts are courts of Dubai.
Yes.
I can. Recently, the judgment of Court of Appeal, that is the case of Ashok Kumar Goel versus Credit Suisse. Court of Appeal already rejected that if the jurisdiction is Dubai court, then case will be not run by the DIFC.
And my lord, in any event, even if he hadn't admitted jurisdiction by the admission of paragraph 11, he's clearly submitted to the jurisdiction engaging with these proceedings. It's extraordinary in our submission that at this stage, day one of trial, a jurisdictional issue is now being raised in respect of a claim in which judgment has already been given.
Sir, when fact is coming out, because we connect to this case just a week ago, so when fact is coming out, court should not ignore the facts.
Oh,
And
no
it
basis.
raise any time, sir. There is no limitation for that. If we find any new facts, that should be always be present in front of the court. And
the court
allow us for that.
There has been, as Mr. Reid says, an admission on the pleadings about the that the DIFC courts are courts of Dubai, and there has been judgment already in this case on several occasions, which impliedly accepting jurisdiction. And unless if some point arises, you'll have to take it elsewhere. Right. So I'm refusing application number 17. Are there any other preliminary applications that need to be dealt with? Mr. Reid, that you're aware of?
Or indeed aware of on the part of others.
Right. Now, you, Mr. Mehta, at one stage in your last statement, you mentioned your skeleton argument. Do you have a skeleton argument?
Actually, I'm not that much expert that open to. Okay, let me try to open this.
Is there a skeleton argument by the?
Yeah, it is with me. Yeah, yes, sir.
But where is your skeleton argument?
Yeah, so my skeleton argument is actually this prime surprise just came today morning, but my skeleton argument cover. Yeah.
It came in yesterday.
9, my lord, in bundle A. It's been
I've just got it. I hadn't realised, but it wasn't with the papers that I was given. All right, that's helpful. Thank you.
My lord, I suppose the only other thing, which isn't a formal application, which is just to signal that in our opening and in our cross-examination, we will want to share documents
yes.
in order that, and I just want to make sure we don't waste half a day having technical issues with the sharing of documents.
When you say share documents, what precisely do you mean?
Within the case line system, there is a procedure by which Mr. Hogan can put a document up on case lines
right.
so that we can, and that would be our preferred way of dealing with matters. I don't know if Mr. Mehta has them in paper, has the documents on paper. It may be that he would find it easier to deal with them on paper. But in any event, we need to ensure that we can move efficiently through the documents without technical issues.
So far as I'm concerned, tell me if this is not what you have in mind. I'm using the case management system, which has the trial bundles on it. If you tell me a page or anything, I can get to that page pretty quickly. I always forget how, but I can do under fine and so on.
Fine. There's a magnifying glass.
Yeah, then you put number in, page number in. Is you had in mind?
Okay, so we would like some comfort, if that's possible, that Mr. Mehta is going to have access to the same system or the documents on paper. But,
Mr. Mehta, do you have access to the court management system for this case?
What is that, sir?
Well, it's I'm not sure how to describe it. It contains all the papers in the case.
Case line, yeah.
Sorry? Case line.
Yeah.
Is it called case line?
That's the brand name of the system, I think. Yes, case line.
Yes. So if I can we'll just test it. One, could you turn to bundle A, page 72?
Sir, I will do practice in due course. Really, I have no good knowledge of computer. I am taking help and I will learn it. No issues.
Well, just try and make sure we can get one document, just as a matter of interest.
No, it will be not an issue. I will do that, sir. I will do.
All right.
But again, sir, my request is really, being a layman, although I having a good case, but I afraid that I will lose just due to the time will not grant for my defense lawyer. And really, I'm little disappointed with this. If you can do something really great for us, sir.
Well, I've heard the applications and I've made my decision not to adjourn the case. What we'll do is we'll resume on the 5th of October, that's Tuesday, at 11:30 Dubai time, which is 8:30 UK time.
Yeah.
And at that stage, we will have an opening, a revised opening from Mr. Reid. What I hope he will do before that is to revise his written opening.
So Mr. Reid will submit the new argument?
It'll be revising the argument, so it won't add new points against you, but it will take out stuff that is not relevant to the case against you. Do you understand?
No. So when I will get a copy of Mr. Reid new allegations, actually, or what are the points I need to address?
When do you think you'll be able to do that, Mr. Reid?
Well, there's a fair amount, as you, Lordship has seen, it's a fairly, if you're talking about the skeleton, it's a relatively long document. There would need to be a certain amount of move, which I apologise, but that will require a certain amount of moving around. I want to be realistic about the time. I mean, tomorrow evening we could try.
But if it is tomorrow evening, would it be sensible then to? And how long is Mr. Gunes going to take?
Well, I can't say how long Mr. MEHTA wants to cross-examine him. I mean, it's a relatively short statement, and he wasn't directly personally involved. So one would have thought it should be possible to cross-examine him relatively briefly.
I wonder whether if you submit your revised skeleton argument by the end of tomorrow, that is to say, Mr. MEHTA, which I don't want to inquire inappropriately, but which country are you in?
India.
In India?
Yeah.
What is your time difference?
No, that is
what time is it in
my
India?
suggestion is that once Mr. Reid submit the fresh argument, so at least give us 48 hours to reply our argument and all the things, so that then we should go ahead.
Mr. Reid,
can I make a rival suggestion, which is that essentially all of the arguments that, as your Lordship suggested, that have already made against Mr. MEHTA and RENISH are there on the face of the skeleton. If your Lordship wants a document that is going to be of assistance, what we could do is, during the course of the trial, essentially streamline it down, cutting out the bits against Prime, which are obviously allegations against Prime, specifically allegations of conspiracy and unjust enrichment that come out, but that we build up the skeleton, having streamlined it, build it up during the course of the trial. And then we'll have a written document which will be, in our submission, more useful than a skeleton at this, a redrafted skeleton at this point, which will put junior counsel to a huge amount of work, and will just then provide the premise for Mr. MEHTA to suggest that he's been unfairly treated and that it's been some sort of procedural.
I think it's only fair to Mr. MEHTA, with the change of case, the change of circumstances, that he has a proper opportunity of considering a revised skeleton so that he can. Frankly, I found the skeleton quite difficult to digest at first or second reading, and it would help me certainly if there was a revised skeleton limiting the arguments to the case against Mr. MEHTA and RENISH. In those circumstances, what I'm wondering is whether if we skip the preparation on the 12th of October as day 8 and move everything back by 1 day so that you produce your skeleton at the end of tomorrow, that's the 4th, and that we start with the opening on the 6th, and will there be need for opening by both parties, or should we just go straight into Mr. Gunes? I suppose
we could adopt a traditional approach, which is that the claimant opens, and
So should I share something?
Wait a minute.
There's another issue on the board, which is which Mr. Wheel has brought to my attention, which is that it would be helpful to us to know precisely which passages of SADA are adopted by Mr. MEHTA, so that we know what we're dealing with in revising our skeleton argument.
Well, he may not be in a position to tell you yet because the things have changed and he's only just been asked to focus on that aspect. I think you've got to prepare your skeleton argument without that. And you can always put in something about whether or not it's accepted and what consequence of it is or isn't. But that's up to you. I think if we have skeleton argument by the end of tomorrow, and by the end of tomorrow, if you had it, if we had it by what time is it in India now, Mr. MEHTA?
It's just 1.5 hours more than Dubai time.
Right. Dubai time now is Dubai time now is
1 o'clock. Sorry, 2 o'clock.
Yeah. And so it's, in India it's 3:30. Is that right?
Yeah.
Well, plaintiff's revised skeleton by close of business Dubai time tomorrow. So by 5 p.m. Dubai time tomorrow.
That's 2 p.m. UK time, my lord.
Right.
Essentially, that day to that is quite tight.
Well, it's I think inevitable. I think Mr. MEHTA has got to have a proper opportunity of considering it, and if oil has to be burned, so be it. So by 5 p.m. Dubai time on the 4th of October, you will produce a revised skeleton argument focusing the case against Mr. MEHTA and RENISH. And what I suggest then is that we defer the opening until, so nothing happened on the 5th of October. It gives Mr. MEHTA a clear day to consider the revised skeleton. And what I suggest we have is the opening on the 6th of October. Do you want Mr. Gunes' evidence that same day, or do you want to have it late, the following day?
Later.
Mr. Gunes, well, why do we make Mr. Gunes' evidence on the 7th and Mr. MEHTA on the 10th and 11th? then we have Claire Lavine on the 12th, who will be quite short, I imagine, and therefore will give time for preparation as well on that day. And then final submissions on the 13th and 14th. Now, I don't suppose anyone's happy with that, but does anyone want to make any particular suggestions of alterations to that? Mr. Reid, you reasonably content?
My Lord, I have no particular amendments to proposed amendments.
Mr. Mehta, that gives you a reasonable period after the submission of the revised skeleton.
How much time I will get?
Sorry?
How much time I will get?
You will get it by 5 p.m. Dubai time, which is 6:30 Indian time, I think.
No. So what I suggest, as you had given Mr. Reid almost 1.5 days, so how much I will get to prepare myself, because I don't having any lawyer or anything at the moment. So
you have from now until the case will.
Of Mr. Reid, because once I will get allegation, then only I am able to.
Mr. Mehta, let's be clear. The case against you is not being expanded. There is no additional allegations will be made against you. What will happen is that it will be recast to avoid confusing the issue by reference where it's not necessary to the case against Prime.
So should I ask one question?
Yes.
The fraud judgment is already set aside in end of May judgment.
Yeah.
By Your Honor. So any document before that and any presentation before that now will make any sense in current argument or no?
I'm not sure I understand what you mean. Are you meaning written arguments?
Means up to end of May, whatever evidence submitted by claimant, so all that evidence already observed during the argument of 31st May or something, whatever the trial date, and then the charges of fraud was set aside by my lord. So any evidence or any submission which was done before, is that allowed to repeat by the claimant, or how it is?
Yes.
Only fresh evidence will be checked by the court? That is my question.
All the evidence. We start this trial without any preconception about the evidence, whether it's accepted or not. The last hearing was a hearing for setting aside what's called an immediate judgment. That is to say, a limited judgment on certain allegations and arguments. Now we're having the full trial where the plaintiff, the claimant, SBM Bank, has to prove its case, and it can refer to all the documents and all the arguments.
Okay, so we should also allow to raise all the related questions regarding their contract and personal guarantee, all that.
Sorry?
So during final trial, we also allow to raise all the questions related to the contractual obligation and personal guarantee and all this thing.
No, because that has been dealt with by a judgment. The court has found you liable contractually to pay.
It was very short judgment with a limited access. So now, as they also allow for the claiming fraud against me, so should I also allow to put my submission on the contractual obligation as well? And
no, that has been the subject of a judgment against you. The judgment on the fraud part was not a judgment that there was no fraud. It's simply a judgment that it was not clear on the material before the court at that stage that there was a fraud. And that's different. That is the issue which is now going to trial.
So only new material will be considered by court because the old material already observed by the court. That's only I just want to understand.
All the material relating to the fraud allegations will be before the court.
Okay. Okay. And contractual obligation, I'm not able to speak anything on personal guarantee or contractual obligation.
Insofar as it's relevant to the fraud case, yes, of course you can. But there is judgment against you already, which is not an issue on the contractual claims.
New fact will be represented by us, will be considered by the court or no?
Not on the contractual judgment.
So, okay.
So look, we'll resume then at 11:30 Dubai time on the 6th of October with Mr. Reed's opening, and you have an opportunity at that stage as well to make an opening on that day to outline your case.
Yeah.
What I think you must do though before that happens, but by the end of the 5th of October, Mr. Mehta, you must indicate which parts of Mr. Sada's evidence you want to rely upon and which parts you want to challenge. And the same with Mr. Farhang's evidence. Do you understand? You can just put paragraph numbers. Do you understand?
Yeah.
And you lodge that with the court by 5 p.m. Dubai time on the 5th of October.
Okay. And sorry again, I'm not good in law. So, are you releasing Prime Energy and Mr. Sadar and Mr. Farhang from this case, or how it is?
I cannot compel them to attend because they are not in the jurisdiction of the court. Therefore, you can rely upon, if you want to rely upon them, you can rely upon their statements or part of their statements, and you can bring those statements before the court and criticize bits that you disagree with.
Okay.
All right.
There's only one other matter which I would raise, which is in your on the last hearing, which was a hearing of an application for disclosure. Your Lordship made an order for a disclosure statement to be produced by Mr. Mehta, and there has been deafening silence on that. So it would be very helpful for the claimant's perspective to have that statement, which frankly ought to have been provided weeks ago.
Yeah. Mr. Mehta, can you do that?
Sorry?
Can you provide a disclosure statement?
I don't understand, sir.
Right. I'm trying to find an example of a disclosure statement. Mr. Reed, can you? Is the one in the bundle somewhere?
Yes, they are in the B bundle, my lord.
B
bundle. So
the statement.
D138.
Yes. Mr. Mehta, do you have B138?
I will write down. I will check, sir. P for
B for Bravo.
Okay, Bravo. B
138.
138. Okay, sir. Okay, I will check.
And that is an example of a disclosure statement. That's signed by Mr. Gunes, and it's his disclosure statement. And what you were ordered to do on the last occasion was to provide a disclosure statement. Can you find the order for me, Mr. Reed? Here we are. No.
Page C118.
Yes, at C for Charlie, 118, Mr. Mehta. I ordered you to I remember ordering it, but I can't find it.
If you are putting numbers in just for one day, really it will be difficult for me. Just I'm explaining my reality. Remain with you only, because I don't having a numbers of people and staff, and I'm alone and not having a practicing law. So please also consider my situation as well.
Mr. Reid, is it really going to help matters? Is it better just to get on with the case?
We want to get on with the case, but I think we're entitled to know what searches, for example, have been done. We'll want to cross-examine him on this. It's a short statement. It's 2 or 3 pages. He's had until since the 2nd of September. He's made no attempt to comply with this order.
Well, Mr. Mehta, I've made an order that you produce a document production statement. That was the 16th of September, and you haven't done it. Would you do it, please, by the beginning of by 5 p.m. on the 5th of October?
Okay, sir. And so you are discharging Prime and Mr. Sadar and Mr. Farhang from this case, right?
I'm not releasing them. I cannot force them to.
Always there. So I'm just asking your decision on this, because my objection is always there, because it will really affect too much to this fact of this case. So I'm just asking that what is your order, because my objection is always there and I'm not agree with that decision.
I cannot make any order compelling Mr. Sada and Mr. Farhang to attend. But instead of that, I can indicate to you that you can rely upon those parts of their statements that you wish to rely upon, and you can criticize those parts of their statements that you don't wish to rely upon.
You should not allow Denton to do such type of last-minute surprise and play with the court.
Oh, they're perfectly entitled to settle the case with one of the defendants. Well, if there's nothing,
and that's all.
Right. Very well. We'll adjourn at this stage, and Mr. Reid, if you can have the timetable circulated, please, just for avoidance of doubt. And when it's been circulated, perhaps I'll make an order in those terms through my clerk.
My lord, yes. Lord, the only other thing, I wonder whether it would be worth scheduling a technical rehearsal for Mr. Mehta, if Mohammed could make himself available. I'm really very concerned that the opening is going to get bogged down in protestations that Mr. Mehta can't find documents or doesn't have access to documents. When we start, we will need to progress, and I have grave concerns about the conduct of Mr. Mehta.
Mohammed, are you listening?
Yes, my lord.
Could you try and establish with Mr. Mehta after we finish that he is conversant with the system and can produce documents?
What I will do, I'm more familiar with the paper, so whatever I need to argue, I will take a print with number. So I will simply go to the paper and request court to, this is a document number and this is a para number, like that.
And you'll be able to find documents if someone refers to them during the court trial?
Yeah, I will try, sir. I will try. I'm not sure.
Oh, Mr. Reid, if Mr. Mehta is going to use a paper documentation, I suspect that is the way we're going to have to go, and we'll do our best.
Well, we may need another day, particularly on cross-examination, because
we can sit extra hours if necessary. We can sit extra hours if necessary, and we can. And if we need another day, we'll have another day. Let's hope we can avoid that. I think you must recognise, Mr. Reid, that had the settlement with Prime been established a few days earlier, we wouldn't need to build in the delay at the beginning. But there we
I
are.
wasn't.
Not blaming you. It's simply that these things have consequences. Very well. We'll resume at 11:30 Dubai time on 6th of October. All right?
Yeah.
Thank you very much. Mohammed, if you can send